Hi class, how are you today? This is CS Shantanu Bhandary, and I think I've already given a lot of introduction about myself in the previous slides. So rather than just wasting your time, we'll just quickly start with the thing that we actually wanted to discuss today. Please actually remember that this is the second part of the introduction. So we have already discussed one of the part of the introduction regarding the checklist for secretarial audit. However, this is like a continuation of that same part. So we'll discuss few of the aspects just in brief under this introduction part. And once this is completed, we'll move on to the detailed orientation of this whole chapter, of the chapter as a whole. I think in the last class we have discussed about the general compliance that has to be followed under the Region of Companies Act 2013. We did discuss about the alteration of MOA and AOA, although we haven't discussed as to what is MOA and AOA, but obviously I'll cover that particular thing separately when we discuss everything in detail. We have discussed about the issue of shares by private placement, by owners as well as right share. If you actually remember, I mentioned that right share also have a thing attached to them called as right of renunciation, while bonus shares, obviously, even if it has a right of renunciation, nobody will right to renunciate. Renunciation means just a transfer that if you are not taking the shares that are being issued by the company, you have the right to actually pass this on to one of your friends or maybe relatives, and in case they are able to pay to the company to the amount of shares that they actually wanted to buy, so they can buy the shares. So usually right of renunciation, or the concept of right of renunciation, generally comes into existence for a right issue only. However, for bonus issue, obviously it's free of cost shares. So whatever is being issued, obviously it's being issued without paying any money. So obviously nobody would like to just pass it on to anybody else. Then we actually discussed about sweat equity shares as to what they are. And now we'll start about the calls. There's a topic called calls on shares and debentures. Now, I think probably maybe in your I was school or college, you must have actually dealt a chapter in accounts which talk about calls on shares and debentures, if you would remember. So I understand there are different boards, maybe ICSC and CBSC and maybe some other board as per. So these are the nationwide boards, but maybe some regional board. So obviously, as I said, whenever there's any topic which already has been covered, what I'll do is I'll not actually just pass it on. I'll try again to explain that topic to you, so that in case some of you have already gone through the topic, obviously you guys will have a kind of a recapitalization. But for all others, it would be obviously a new topic. So call obviously means, for example, if the share is worth rupees 10 and you have paid 2 rupees on application, 2 rupees on allotment, so the rest, which is like 6 rupees, has to be paid in the form of calls. So the company would actually give you a call. So maybe a first call of 3 rupees, then another call of 3 rupees. So the call is the amount of money that is still unpaid, and the company would actually call on that amount as and when it requires. Although actually there's some criteria that has been fixed in that regard as to the time limit within which the company can make a call, and the difference between the two calls has to be minimum number of days. So all these things are there, but just to explain the concept of calls. So call is the amount of money that you actually needs to pay to the company. So out of rupees, a share worth is rupees 10, you already paid 4 rupees. 6 rupees is something that is outstanding, and you need to actually pay this 6 rupees in the form of 3 and 3 maybe. So the company will ask you for the first call of rupees 3 in case you have paid it. Then after some period of time, the company would again ask you for the second or the final call. You actually pay the 3 rupees as well. Then your share will be termed as fully paid, and you will be entitled to receive the dividend, if any, paid by the company. So this is the concept of calls, and obviously in case the money is being demanded and you actually didn't pay the amount of money, then it would be termed as calls in areas. So calls in areas means that obviously you're not able to pay the money, so that is covered under calls in area. So you need to make sure that this does not happen, because in case this happens, then after doing unlimited calls, the company has an option to forfeit your shares. So there's a difference between forfeiture and surrender. Forfeiture is like this concept where it says obviously that you'll be actually liable, or I would say you'll be actually entitled to actually give your share back to the company. I mean, you're not entitled. Actually, the company will take the share on its own in case you're not able to pay the calls. But the other concept is called as surrender. So the other concept is called as surrender. Now, as you could see, probably a blank screen in front of you. Now, this is just only for better explaining, because in that particular PPT, there are a lot many things written. So I suppose it would be really good in case we could take a fresh sheet and probably actually explain the topic there. So forfeiture is already I've explained. So surrender is like a voluntary transfer of those shares. So for example, it may be the fact that you have already paid all the calls in shares, but now for some reason you don't want actually to take the control of share, and you don't want the share to be with you. So you actually surrender the share to the company. So, I mean, whether the shares could be surrendered or not, and what procedure has to be followed in that specifically, would be details in the Articles of Association of the company. So you need to check that as well, but this is more or less the concept of surrender of shares. Thereafter, as we move ahead, there's a concept of a thing called as buyback. Now, buyback is something that obviously means, like if I just talk about its meaning first of all. So buyback is like the company has issued, let's say, just for an example, 100 shares to maybe A, B, C, D, E, right? 100 shares have been issued to every shareholder. So A, B, C, and D respectively, 100 shares have been issued to each of them. Now, for some reason, the company said, our company actually have a scheme in the market that all of those who actually don't want the company share can return the shares back to the company. So in case the company buys its own shares, the company buy back its own share, then it is called as buyback. I mean, when the company purchases its own shares, so rather than selling, usually the company first of all sell its shares, and that at that particular point of time, probably the company may be in the need of money, but after a period of time, maybe 5 years, 6 years, there is no definite period as such, but the company may feel that it has enough financial resources, and actually it would like to have the control of the shares, probably with its own directors or maybe with the other key managerial persons. So what the company actually do is the company try and purchase those shares which the company has issued previously to A. And when actually company buys the share that they have issued for their own company, then that particular procedure is called as the buyback procedure. So for buyback, obviously there are certain guidelines that we have to fulfill. However, please don't forget, whenever you actually talk about shares, buyback, or maybe debentures, or maybe calls, there's a document for the internal functioning of the company that is called as the Articles of Association. You need to actually check that and the provision in that, and then only you need to move ahead. In case there is no provision mentioned in the articles, then obviously you need to amend Articles of Association before you actually move ahead. The other thing that I'd like to discuss with you is in regards to a topic called as debentures. Now, what are debentures? And so debentures are kind of a secured loans, if I could just say in simple words. So they are the kind of secured loans. Now, debentures, obviously, all those people who are actually called as a debenture holder, they are entitled to get interest from the company. The interest may actually be paid maybe quarterly, or maybe monthly, or maybe half yearly, or probably yearly. So depending on the facts and the circumstances, the interest will be paid. But actually the main condition with the debenture holder is not the fact that they'll get the interest, but they'll get a guarantee that they will be paid interest. In case the interest is not paid, the debenture holders are entitled actually to sell the assets of the company. So in case the company actually issued debentures on the presumption saying it's 6% debentures, which means that the debenture holders will be getting 6% interest. In case the company actually didn't pay this amount of interest from debenture holders, maybe quarterly, half yearly, or yearly, as that has been agreed between the company and the debenture holders, then the debenture holders have the right actually to sell the property of the company or the assets of the company and recover their amount of money. And that is the reason it's called as secured loan. So secured means you have some security. As you know that whenever you take actually any kind of a home loan or maybe a car loan, so what bank or the banker do is they keep the papers or the original paper of these property with themselves, and you've been asked actually to fulfill the requirement of EMI, which is easy monthly installment. In case in any month for some reason maybe you're not able to pay the EMI, the bank actually may not do anything. But if this is a routine affair, then what will bank do? Bank will actually come to your home or maybe take your car under their possession and probably auction that particular house or sell that car and recover the amount of money. So that all those things are called as secure, because obviously they have some kind of a security that in case the borrower actually default, then there's no worry, but they can actually recover the amount of money. There are certain conditions that have to be complied with. So debentures are usually issued, if I talk about a particular company which says infrastructure. So generally, except infrastructure, the issue of debentures, whenever debentures is issued, it has to be redeemed within a period of 10 years. But for any of the infrastructure companies, the period has been extended to 20 years. So usually, whenever you issue debentures, you need to make sure that you actually redeem that particular debentures within the period of 10 years maximum. But for infrastructure, actually the period is extended to 20 years initially. But now what has happened with the advent of time, this has actually further increased to 30 years. So if anybody asks you actually what is the period within which the debenture issued by infrastructure company has to be redeemed, so you'll actually say that it is 30 years. So the two things that you need actually to remember is 10 and 30. For any other company except infrastructure, the maximum term for redemption of debentures is 10 years, while for the infrastructure company, it's now 30 years. What is the reason as to why it is 30 years? The reason is that whenever you issue debentures in infrastructure projects, you'll yourself understand, in case you have actually book any kind of a home or an accommodation or a residential flat, maybe in with some of the builders, maybe in Delhi or maybe some any other cities. So you'll realize the fact that infrastructure is something that obviously does not get built in a day. It takes maybe years and years to get built. So obviously the gestation period is quite long. So what I mean by gestation period is like till the time the operation of the company actually gets started. Because in case you're in the market and you're a builder and you want to sell the home, so till the time the home or the house or the home are being made, obviously nobody would pay you, and nobody would actually pay you full amount. So until and unless you actually get ready that particular home or the house, nobody will actually pay you. So until and unless nobody actually pay you, how will you redeem the debentures? So that is the reason for infrastructure, the gestation period or the time within which actually the business will be started is 30 years. Although it's practically understandable that 30 years obviously are not required for any of the infrastructure projects, but just to make sure that it actually does not get default, the government has increased the guidelines from initially, as I said, 20 to 30 years. Apart from that, there's also a concept of transfer and transmission. I think with the introduction of this chapter, if you would like and go back to the introduction 1, you'll realize the fact that right in the probably first 10, maybe just 15 minutes, first 15 minutes, I've tried and explained the concept of transfer and transmission. Now, when I say transfer and transmission, obviously I talk about the shares and debentures. So transfer and transmission are the two words that obviously have their own meaning. But just to make sure that you guys actually realize this properly, I like also to add few points to it, which I mentioned even previously. So the articles and the memorandum association have a great role to play in all of these activities. Articles are the document for the internal functioning of the company, while memorandum could be termed as a document for the outsider. You must have heard about a particular thing called as Doctrine of Constructive Notice, Doctrine of Indoor Management. So Doctrine of Constructive Notice means that anybody who is dealing with the company has to have a particular information as to what the company can do and what the company cannot do. So he has to be sure from his own side what are the powers of the company, what are the powers of the board. So constructive notice means that the person who is dealing with the company also has a responsibility to make sure that whenever he is dealing with the company, has already checked the rules and regulation, including MOA and AOA, and then only he should try and probably enter into any kind of contract with the company. The Doctrine of Indoor Management says, for example, there's a thing which says board resolution. That there was a particular, let's say, particular activity for which a board resolution was being passed, and you actually go to the back and probably say this is the copy of the board resolution that has been passed in the meeting of the board of directors, and it has also been signed by the chairman of the meeting. Now, the person who's sitting at the bank, maybe a bank manager or maybe just a normal individual, may not be able to actually verify whether you are saying the board meeting is held, whether that's true, and whether the sign that has been actually put on this paper is of chairman itself. Because what he actually can do at the most, he can actually verify the signature of the chairman from the records of bank. In case there is any record of his signature, like the chairman's signature, he can just rectify or probably reconcile those signatures. But indoor management means that the activity or this board resolution or the board meeting has actually held within the four walls of the company. So any outsider actually may not be able to verify the facts of this particular thing. So in case anything like this has been brought to the notice of the public, then the public has to, or just a normal individual or the common individual has to believe what you're saying. So indoor management is like whatever has happened within the company, and there's no way actually to verify or to double check that, then whatsoever is being mentioned by the company, the person on the other side has to believe that. But in the case of constructive notice, it is being said that whenever you actually deal with the company, it is not only the responsibility of the company, but it is the responsibility of the individual as well, who is actually dealing with the company, to make sure that they actually go through or make themselves comfortable with the provisions of the MOA and the AOA respectively, particularly the MOA, I would say. So you need to make sure that whenever any transfer or transmission actually occurs, this has been approved by the articles. When I say approved, means that whatever conditions have been mentioned in the articles of association of the company as to when this transfer can happen and what are the prerequisites have been complied with. Now, there's a particular chapter in this study material, I think, that we have discussed about charges. So anybody who actually is not clear about this charges thing, I'll request them to actually go back and check the number of videos that you may have. But because there would be a specific chapter that has been dedicated for the charges, so you need to check that and probably you'll be able to get a better understanding as to what they are. But charges have been divided. So charges is like whenever a company actually take any amount of loan from any bank or financial institution, the bank or the financial institution, while giving the loan, would like to actually have certain kind of assets. So in case the company actually default and does not pay the amount of money, then the bank or the financial institution can actually sell the assets of the company and recover the money. So this is one benefit of creation of charge. The other is in case that there is no concept of charge or there is no mechanism of charge, then what will happen that from the past experience it has been actually learned, corporates are really clever. So what they actually do is they'll try and probably borrow the same amount of money of maybe let's say maybe just an amount of 100 crores maybe. So they'll try and borrow this amount of money maybe twice. So one time from bank A, the other time from bank B. And bank A would actually not able to, in case there is no concept of charge, then the bank A will not be able to verify whether bank B has already advanced a certain sum of money to the company. And similar is the case with the other way. So the charges concept has not only been introduced to actually give a strong position to the bank or financial institution, but they are also being introduced to verify that whenever any property has been given in the form of charge, or any charge has been created by the bank or the financial institution on any of the property of the corporate, then it should be actually noted, and so that the other party who is extending some form of credit on the same property is aware of that particular fact, and they should be much cautious before they actually give any amount of money in the same asset. Because in case the asset is worth only, let's say, 100 crores, and the company has already taken a loan of 90 crores on that property. So I think even if you go to the bank and ask for a loan of maybe, just an example, rupees 100, so the bank will give you just 85% or maybe 90% loan, because with property it's quite unpredictable. It may actually appreciate and it may actually depreciate as well. So this is the reason as to why 10 to 15% margin is maintained. So as you could see that in case the property is worth 100 crores and already 90 crores have been borrowed, so obviously there's no further amount that could be borrowed. The corporate, which is called as A Limited maybe, has already exhausted the amount that could be further borrowed. So there's no further amount that could be borrowed. But in case this has not been mentioned or not been recorded anywhere, and it is just between the A Limited and the bank, maybe called as SBI, so obviously nobody would be able to actually verify this fact. But in case there is some provision like what we have today, that A Limited actually filed this declaration or file a form with the ROC, Registrar of Companies, in the form CHG1, which is the creation of charges, then probably PNB or any other bank who is about to advance any amount of money to A Limited on this property would actually be able to verify that already there's a charge of 90 crores, so we shouldn't actually give any further amounts to A Limited. And in case we are giving that, we are actually giving it on our own risk. So we actually cannot held liable or probably say that anybody else is liable apart from us for this particular debt that we actually want to intake. So obviously it gives you a clear or the wider picture. It also says that whenever a charge has been created, it has to be registered by the company within a period of 30 days. There may be procedure which actually refers to the condonation of delay, which obviously would be discussed later on. And similarly, when the charge is being created, there are various ways. Various ways means that when the amount of money is being paid in full, then the charge would also be satisfied, like the charge would be removed on the particular assets, and the company would again be free to borrow any amount of money from anybody else. Apart from that, there may be some change in terms and conditions. So obviously that can also be taken care of. So what I'll do is, when I actually come back on the detailed side of things for these charges, I'll take you to the Ministry of Corporate Affairs website, and we'll try to show some of the index of charges to yourselves. So obviously you'll actually able to see that. Now, as we move ahead, we actually come to the topic called as the meeting of directors, shareholders, and the other stakeholders. So can somebody actually tell me what is the difference between the word called as shareholder and stakeholder? Is there any difference in these two words? If your answer is no, the answer is incorrect. If your answer is yes, I'd like to know the reason. So presumably you can pause the video maybe for probably a minute or something, and you'll actually try and figure out the reason. But I'll try to actually show that what's the exact difference between these two. So shareholder is only that individual which has invested certain amount of money. So obviously the shareholder has the relation only in terms of investing money with the company, while the stakeholder is an individual which may have invested money or may not. Like for example, so if I could give you the example of shareholders, a shareholder is generally anybody who has invested a certain sum of money in the company. It does not really matter whether it may be just 1 rupee or maybe 1,000, but anybody who has acquired the shares in the company, whether just 1 share or maybe 10 shares or maybe 100 shares, is called as shareholder. However, there is also a fact or a thing called as small shareholder. So anybody who has invested an amount less than 20,000 would be termed as small shareholder. But obviously that's a different thing. So stakeholders are anybody who actually may have invested or may not have invested money. The examples could include maybe your supplier. So your supplier may not have acquired any shares in your company. They may not have actually invested anything in your company. Maybe your consumers. So again, consumers not sure whether they have invested or not. But either way, they would be termed as stakeholders. Then maybe your employee, the employee of the company would also be called as the stakeholders. So these are the few terms that are covered under the definition of stakeholders. Now you'll realize by these three examples, the stakeholders, as I mentioned, are those individuals by these names you'll be able to figure out who actually are getting directly affected by the company. In case the company actually grow, their growth will be obviously their growth will be also definite. But in case the company actually falls, then obviously that's for sure that they will also suffer. Supplier will also suffer, consumer, and same is the case with employee. Now, how they will suffer? Supplier will suffer because of the reason the company is not able to actually give good sales. As a result of which, when the company is not able to sell its product, obviously it will not take much goods from the supplier. And any amount of money which the company has actually to pay to its supplier would also get delayed because obviously the company may not have such financial resources to pay the amount of money back to the supplier. Now, how the consumer suffers? Consumer suffers because of the reason that consumer actually look always for quality and sometimes, depending on the type of consumer as well, quality and low prices, right? So these three essential ingredients that the consumer always look for. In case the company is not able to actually keep happy suppliers, then obviously supplier will not be able to supply the goods to the company. As a result of which, the consumer obviously would suffer because the company would not be able to in turn generate the good amount of product and may also be not able to sell them at a low prices. So prices would be high and then the consumer would be unhappy. Employee, obviously, I think a person or an individual who has most of time interaction with the company. So employees generally work for salary or maybe wages. So obviously when the company is not doing good, there are chances that the salary or wages may not get increased, or there are chances that the salary or wages may not be even paid at the regular intervals. So obviously you could see that everybody and anybody is getting suffered just because the company is not doing good. So all those who actually have been named herein would be called as a stakeholder because of the reason I mentioned. Now when we actually talk about a thing called as meeting of directors, shareholders and stakeholders, so if I could just write it down for you, there are few kind of meeting which I think we all must have actually gone through. EGM, board meeting, class meeting. In case the board has formed any kind of a committee, then committee meeting, right? So obviously AGM is that which is called as the annual general meeting, which is held obviously once in every year. Now there is a certain timeline within which AGM has to be held, usually within 6 months after the closure of the financial year. You can ask for the extension, but extension is not your right. It has to be approved by the central government. In case no approval has been given, then obviously you need to hold within this period of time. Recently, I think day before yesterday, or maybe just last few days, I've heard maybe that SpiceJet was not actually able to hold the AGM within the due time, so they have asked for the extension and they've got the extension. So extension, as I said, is not your right. You actually need to prove as to why the extension is required. Maybe the books of accounts are not ready, and if not, then what is the reason for that? So you need to explain that thing. EGM, as the word suggests, is called as Extraordinary General Meeting. Now, just before I move to the AGM, I'd like to mention that in AGM, only and only 4 business are there, which are called as the ordinary business. Anything that has been discussed over and above that 4th business would automatically be termed under special business. Now, please note that there is a lot of difference between special business, ordinary business, special resolution, and ordinary resolution. It is usually, so I'm not saying that this is not the fact, but usually not the case that for ordinary business you have to have ordinary resolution. For special business you have to have special resolution. This is not a thumb rule. It may actually be the case at some point of time, maybe a coincidence or something, but this is not a matter of rule that for ordinary business, ordinary resolution, and for special business, special resolution. Now let me actually give you a few examples as to what constitutes special business maybe. So for example, if you like to change the name of the company, so that is a special business. Anything related to mergers, amalgamation, or probably things like that will also be covered under special business. You wanted to alter the articles of memorandum, that is also a special business. You want to change the registered office of the company, that is special business. So this is not just a complete list, but just to explain you, I've actually given what constitutes special business. Now, when we talked about special business, it's really essential for us to actually discuss the ordinary business as well. I said there are 4 business. So 4 is the adoption of annual accounts, including profit and loss and balance sheet. Declaration of dividend in case the company wants to declare the dividend. Appointment or reappointment of the auditor. And appointment or reappointment of the director. So, director. These 4 are actually called as the ordinary business because, as you could see, that these activities are something. So, obviously, if you don't approve the annual accounts and actually don't present it to the shareholders, then what is the use of calling the annual general meeting? Then, what about dividend? So, obviously, as I said, like in the starting of the video, and obviously you'll appreciate the fact that whenever you have invested any amount of money with any of the organization or a company, you actually look towards the ROI, which is called as return on investments. So in case you have invested some money and the company is not able to actually give certain extra amount of money to you in return for the amount that you have invested, there is no use of investing maybe. So that is called as dividend. So obviously that is a routine affair. Like the shareholders actually wait for the AGM of the company every year to know whether the company wants to declare the dividend, because as I said, dividend declaration is probably not as a matter of law that you always have to declare the dividend. Depending upon the profitability of the company, and thereafter even the company has profit, then also it is under no obligation to declare the dividend. Appointment of auditor. So auditor is an individual, obviously a chartered accountant, who has to conduct the audit of the company. So you need to make sure that obviously you have an auditor with you. In case the auditor is a person who has already served his term in the office, then he has to actually retire and somebody else has to come in. In case the auditor wants to resign for some reason, maybe due to some of the professional reason or personal reason, you need to appoint new auditor to get your books audited, because these are interconnected. If the audit cannot happen, then obviously the balance sheet and profit loss cannot be finalized. If the balance sheet and profit loss cannot be finalized, obviously you will not be able to reconcile the amount of profit or loss or that the company has probably made. So until that particular point of time, you will not able to declare the dividend, because dividend is only paid out of profit and not out of capital. So you see that all these things are interrelated. The last is the directors, the appointment and resignation removal maybe. So obviously directors are called as the hands and brains of the company. So whenever we talk about the directors, obviously we need to make sure that as per because there have been some different guidelines to the public and the private companies. So in case you are actually a public company, you need to make sure that you have adequate number of independent directors. We'll actually discuss this just later on, but you need to make sure that you actually comply with it. And if the directors are retiring, so the new directors should actually come in, so the requirement of quorum could be fulfilled. So these are the reason, because until unless the quorum is fulfilled, the meeting cannot happen. And the meeting cannot happen, so anything that you have declared in a meeting in which the quorum was not present, obviously is null and void. So in case you have discussed about the adoption of annual accounts, because before the annual accounts are being sent to the shareholders in the form of notice and agenda, along with notice and agenda, it has to be approved by the board. So if the board does not have adequate quorum, then any adoption that has been made by the board in that meeting may be termed as null and void. So all these things are interrelated. But when we talk about meetings, there are few powers that have been given to board of directors that could only be exercised by them, but we'll discuss on those things just shortly. Then comes a thing called as the minutes book. Now, I'm not sure as to how many of you actually have seen the minutes book, but what I'll do is, as and when we move ahead, because it's really useful for everybody who's actually watching this video and probably are doing company secretaryship course, to actually not just take the bookish knowledge, but obviously verify or probably actually get some glimpse of the practical side. So what I'll do is, as I said, once we actually move on to the details on this chapter, we'll try and probably figure out and check the I would say the practical side of things as well. So to make sure that you only does not get only the theoretical view, but also the practical perspective. So what I'll do is, I'll try and show you the way the minutes are being prepared, because in case you guys have been doing some kind of training, then obviously you must have seen the minutes. Usually the minutes for the private company especially, generally, so this is not as a matter of rule, because as I said, there are different circumstances under which you need to prepare the minutes. So the things could be different, but generally for the private company, the minutes of the meeting are just copy paste. So you need to actually, if I just, so Control C and then Control V. So usually this is what most of the people actually do with the private companies, because government actually does not have much to deal with the private companies, because of the reason the money that is invested in private company does not belong to the government maybe, or does not belong to the general public. But when I say general public, it means, as you know, that the maximum number of members in private company can just be 200, while there's no limit to in the public company the maximum number of members. So obviously the stake that or the amount of money that is invested by the general public is far and wide more in public company than private companies. So the government is not much interested with that. I mean, I also know some of my probably, if I'm not wrong, I could say that some of my professional colleagues who are into the, because I actually work for a company, but they actually are on the practicing side of things. So I know that some of the clients actually come to a PCS maybe, or a chartered accountant maybe, that whenever a minutes of meeting are being required, the chartered accountant or the company secretary can draft the minutes and probably they'll sign and file it. But obviously if you go and go to the company, maybe the registered office, and ask for the minutes of meeting, and the company has been in existence for more than maybe 20 years, there's least possibility that they'll be able to show you probably even the minutes of maybe just 2 to 4 years maximum. Because the reason is they don't keep the record for that. So that is also a problem. So minutes of meeting is kind of a documentary evidence as to what has been discussed in the meeting. And minutes obviously certify as to actually who was present and who was actually the chairman of the meeting, what has been discussed. Now lately I think minutes actually also get importance when so when SS1 and SS2 code introduced. So SS1 stands for board meeting, the way it should be conducted, and this is general meeting. So obviously there have been secretarial standards on that area. But as I just said, like I think just in the some of the previous video maybe, that if you are aware that starting September, I think which is just 2 to 3 days from now, so what will happen? The new secretarial standard would come in. The SS1 and SS2 are actually getting revised completely. For more details, I'll actually take you through the website of the MCA. But just to make yourself sure about it, you actually can go to the website of MCA and can have a look for yourself. Also, the other thing that has to be considered, right? So, as I said, you're more than welcome actually to go to the website of MCA and look for yourself. But otherwise, I'll take you through that, and then probably you'll be able to see that. But just to make sure that it does not create any kind of confusion in your mind, for all those who are actually attempting the paper in this December 2017, they have to be assured that whatever is being taught at this particular point of time, whatever is mentioned in the study module, would just only and only be asked to them. In case there is any question, then they actually need to answer it as per the way we have discussed. They actually didn't need to consider anything that has been brought after probably July 2017, because in the examination it's being asked just only 6 months before from the examination. So anything that has been done in September has nothing to do with the December 2017 exams. But for all those who are actually watching the video, and obviously they need to give July 2018 exam, they have to be cautious and probably know what details are there for Secretarial Standard 1 and 2. The latest details would obviously be shared with you probably in next year whenever we shoot next time, or you can yourself actually go to the MCA website and look for yourself for all those who are June attempt 2018. But December, please don't actually give any importance to that. Okay, then you also need to make sure that board meeting is being conducted. It has the request of quorum. Now, with the advent of time, obviously you'll appreciate the fact, in case, as I said, some of you are doing training, or maybe some of you are maybe working. Then, as you know, that the board meeting can also be done now through audio and visual means. But whenever you actually do these kind of meetings through audio and visual, because this is an important documentary evidence that has to be preserved throughout the lifetime of the company, so you need to make sure that there is no failure for the audio or the visual kind of thing, and there is no kind of disconnection between audio and visual, whatsoever way you've been using. Maybe you are actually going on Skype on the audio, or maybe you're actually going on the video as well, or maybe just both. So whatever is the cause of action, or probably whatever the way that you choose, you need to make sure that obviously nothing happens by which if somebody actually wants to hear what he's saying is being prevented. So you need to make sure that the connection is 100% up and running, so that there is no issue in the end. The need as to why the audio and the visual have come in place is obviously because of the fact that you yourself would appreciate the fact that it may not be possible for the directors to actually present in all the meeting because around the globe, obviously you can't travel, you can't present, even if I say just not around the globe, but just within India, you can't be present at two places within intervals of 10 to 15 minutes. So obviously you can't travel that fast. So technology has given us some of its benefit, but obviously you cannot travel that fast at this particular point of time. But you have to make sure that you be there in the meeting to actually make sure that you are aware of all the facts and circumstances. So considering that in mind, it has been actually taught and agreed that we should also have audio and visual meetings, so that it actually gives a convenience to the directors, or maybe all those who are responsible, to actually discuss whatever they want to discuss for the welfare of the company, and probably the distance should not be any hurdle as to the welfare of the company. Now, if I talk about the annual general meeting, I think I've already explained that. So you need to give the notice for the meeting, and the notice, the time period is 21 days. So when we talk about 21 days, it says 21 days has to be the clear notice, clear days notice to be correct. So when I actually talk about 21 days clear days notice, it means that you can actually give also notice of 24 days before, but because 21 days is like what, 3 weeks? 7 into 3, 21. 3 weeks means 3 Sunday. So You need to make sure that the notice actually reached the shareholder or concerned individual ahead of the meeting. At least 21 days notice has to be given. So, but in case you are actually trying to take the precaution, probably you can send a notice even by a margin of 24 days maybe, because there are 3 Sundays. So when you say clear days, it means that should be working days except Sundays. But otherwise, it is 24 days. But whenever you actually say 24 days, you'll just say 24 days notice. You will not actually say that clear days, because clear means that it does not include any kind of weekends, so when I say weekend, it just means Sunday. As you're aware that because this is something that hasn't changed as per the 1956 and the 2013 Act has been the same all the while. So it says then in case that you want to reduce the notice period, like just maybe wanted to call the meeting probably at a shorter notice, then you need to make sure that 95% of the members actually have agreed to this particular area or agree to this particular thought, and then only you will be able to actually conduct the meeting at a shorter notice. There are a few requests as to the timeline and the things in that particular thing, but we'll discuss as we actually move on to the detail side of the area. Then the second thing, apart from what we've discussed in terms of AGM and the board meeting, could be now the dividend section. So dividend, as I said, is not a matter of right. It will only be paid whenever the company has any profit. And even so, there are 2 requests. If the first is the profit, and then the intention or the will. So you have the profit, being the owner of the company, you have the profit, and then you also have an intention that you actually will be paying the dividend. Then only you will pay the dividend. But in case you just have profit but does not want to pay the dividend, then there is no compulsion in that. But whenever a dividend has to be paid, it will be paid within 30 days of its declarations. For example, if you declare the dividend on 1st of March, then it has to be paid within 30 days. It means by 31st of March, you need to actually pay the dividend. Or every dividend that will be paid to the shareholders will always be credited directly to their bank account. So the dividend will not be paid in cash. Only and only by check or maybe ETF, so electronic mode. So what do you know what is ETF? So it's electronic. So EFT, sorry, funds transfer, electronic funds transfer. So you need to make sure that you either follow a bank or a check method, or probably just remit directly to the accounts of the shareholders through electronic means. Then there's a concept of thing called as CSR, which is obviously nowadays a kind of a buzzword. Everybody actually trying to do something or the other for the society. Now, we are not sure as to how much they do, because whenever you actually watch the telly or the public radio, you actually hear that they say that whenever you actually purchase a product, a portion of maybe 1% or 1 rupee or maybe 5%, whatever, is actually being given or is actually being utilized for the benefit for the underprivileged child, which actually includes building education institutions, providing them free books, maybe planting trees. So CSR is, as I said, a global word. CSR refers actually to corporate social responsibility. So corporate social responsibility, the word means that the company or the corporate, because they have actually earned so much from the society, so they actually have to return something to the society. And because usually most of the corporates, I'm saying most of the corporates, especially the MNC or the multinational corporates, have exploited the natural resources to the best that they can, and even sometimes more than that. So obviously the natural resource is something that you cannot actually generate by your own. So it is the efforts or probably the nature process of maybe thousands of years. As you know that coal obviously cannot be made in just maybe 10 years. It actually requires probably more than 500 years or maybe more than that, even actually generate the coal. So they have actually exploited the resources of the society to the best extent that is possible, and sometimes they have actually misused the resources as well. So it's now their responsibility that they actually make sure that the person who are living in the society are actually get benefit, like some amount of benefit is actually been given to the society back, because they have actually exploited all the resources from the society. So they have taken so much from the society. So it's now their responsibility to actually give some amount of benefits back to the society as well. And society obviously consists of the individuals like you and me, maybe. So obviously this could be in the form of building hospitals, building as I said, education institution, maybe planting trees, right? Or maybe actually doing some kind of sanitation work. So anything like that is covered under corporate social responsibility. There has been a kind of a buzzword in the present market today. There's also been some rules in that regard, which is called as Corporate Social Responsibility Rules 2014, which you actually have to read along with the provision of Section 135 of the Company Corporate Social Responsibility Rules 2014. But there's some condition as to who will follow the CSR, because this is something in which you will actually need to spend the money in the society. So first of all, we need to make sure that obviously it does not get applicable to every company, because some of the company are actually trying to just survive in this competitive market. So it is only for those who have deep pockets and maybe have huge amount of financial resources. So there have been certain criteria in that regard. If I could just write it down for you. So there are 3 criteria. First is, so I'll just first of all write the criteria. Net worth. Then the second is called as the turnover. So net worth, turnover, and then the third is called as net profit. So this is not gross profit, this is net profit. So net worth should be more than 500 crores. So 500 crores or more should be your net worth, or your turnover should be more than 1000 crores or more, plus the net profit during any financial year should be more than 5 crores or more. So the thing that obviously you need to take care of is there's a word called or between these points. So either your net worth exceeds 500 crores, either your turnover is more than 1000 crores, or your net profit is more than 5 crores in any of the financial year. Then what you need to do is you need to constitute a CSR committee, and in that CSR committee there has to be 3 directors, at least 3 or more. You can have more than 3 directors as well, but at least 3. Then out of that 3, 1 director has to be the independent director. So you need to make sure that this actually gets complied, obviously, by the threshold for being able to realize that this is not something for smaller companies or for small companies. This is something for a large or the corporate giant, because maybe this is something that could be achieved, but net worth, this and this. But even this is achieved, then obviously you need to follow the concept of CSR and say certain amount of the profit that you have actually generated towards the betterment of the society. Thereafter there comes the topic of director and key managerial persons. Now there was actually a lot of hope that the company secretary will be actually included in the definition of KMP, which finally happened. So KMP actually stands for Key Managerial Person. Key managerial person. Key managerial, as the name suggests, probably these are some of the important individuals of the company. And don't forget, when you actually are individual, you are also held responsible for so many things that obviously you need to take care of. So you need to make sure that obviously you need to comply with every provision that have been mentioned. Plus, this concept also says that at least 1/3 of the total number of directors should be 1/3 of total. So if I could just write it down much clearly for you. So if the company has 9 directors maybe, then you need to make sure that out of those 9 directors, 1/3 of the directors have to be the independent directors. 1/3 of 9 actually comes to 3 directors, so they have to be the independent directors as such. So independent director, because we are talking about a concept called as key managerial person as well as director, so it's worth actually discussing about this topic as well. So 1/3 of total number of directors has to be the independent director. Now, apart from that, there also have been provisions with regard to some rules like company appointment and qualification of directors rules 2014. Plus, you need to make sure that the quorum was present in the meeting throughout the meeting. Like the quorum is a minimum number of individuals that have to be present in the meeting. So it is different for different kind of meeting. For board of directors meeting or privy directors meeting, it is different. For shareholders meeting and AGM, it is different. So you need to make sure that whatever is applicable in case of public and private company has to be complied with. Now, I've already explained the difference between resignation and retirement. So obviously, I suppose that should be clear to you. Now, we actually come to a topic which is called as registers, filing of form, returns, and documents. Because, as I said, like in the starting of this particular chapter, that this chapter is really far and wide in itself. So it's really better that we actually understand first of all few of the basic concepts, and then only start the crux or the important or the detailed provision of this chapter. Because unless you are aware as to what constitutes CSR and what is the register to be maintained mandatory and what are those that are not being complied, what are charges, and maybe what are articles in memorandum, what are doctrine of constructive notice, what is doctrine of management, then obviously it would be really difficult for you. So so there are some kind of registers that have to be maintained. So there's some kind of register that have to be maintained as per the legal or statutory requirement, while some registers are kind of involuntary and you are under no obligation to actually maintain it. It's up to you whether you want to maintain those registers or not. We'll discuss about that. So first of all, if I talk about the register which is maintained for sweat equity shares, you need to make sure that the company has maintained a register for sweat equity shares, and the register for sweat equity shares is being mentioned in SH3. So whenever we talk about SH and the things of that sort, so SH actually denotes shares, right? If I talk about INC, so they are form called INC1, INC7. So INC actually denotes incorporation. SH denotes shares. Similarly, CHG denotes charges. So now, previously, as per the provision of 1956, the form word number like E form 1832, things like that. But now, so E form does not actually give any idea as to what this form is for. But anybody who is not even aware as to what is INC7 or maybe CHG 1, but definitely that person can tell if he has some understanding of these topics, that INC stands for incorporation, SH stands for shares, while CHG stands for charges. So obviously you need to make sure that obviously when we talk about sweat equity shares, you maintain the register in the form called as SH3. Similarly is the case with the register of employee stock option scheme. If I talk about a thing called as employee stock option, so we must have heard about a word called ESOS, so Employee Stock Option Scheme. There's another thing called ESOP, Employee Stock Option Plan. Now, the similarity, obviously, 3 words, employee stock options. Definitely these shares are being not issued to general public, but they are just being issued to the employees of the company. But the difference between these two, just in a nutshell, is like the individual or the class of employees to which they are being issued Plus, there's also different as to the period of lock-in, because I hope you understand what is lock-in period. So lock-in generally means that if the shares have been issued for you for the period of 1 year or maybe 3 years, then if the share has been issued you for the period of 5 years, and out of that 3 years are lock-in period, then it means that before 3 years you cannot sell this share in the open market. So lock-in period is that period within which you are not allowed to deal with the shares, you're not allowed to probably sell the shares, or you're not allowed to transact the share in any way. So that is the lock-in requirement. So under ESOP, ESOS, the two difference would be, first, it actually vary as to the class of employees to whom they are being issued, and the second is the duration for the lock-in requirement. Now, please also don't forget that ESOS or ESOP are not specifically mentioned anywhere in the course, but I will actually just give you a brief outline as to what they are, so that obviously we shouldn't ignore or we shouldn't pass through that part. So that is the reason I just explained that. Now, the other thing was register of charges. As I said, we also need to maintain a register of charges, so that anybody who is actually giving a loan to the company is aware as to what they are and how many charges have been created to the company. So before giving any kind of financial assistance, the individual is aware that whether any charges of any kind of loan exist on the company or not. So you have to maintain that particular register, and that register has been maintained under a form called CHG7. Now, if I actually go to the MCA website and try to find this form, I'll not be able to do so, because this is something that has to be actually maintained internally, and the format obviously has been prescribed on the website, so you need to make sure that you actually follow those columns and those rows which have been specifically mentioned in there. Then what about register of members? So you need to make sure that you have register of members, and the register of members obviously has to be maintained at the registered office of the company, and all time it should be updated to reflect the new members. So anybody actually who wanted to inspect the register of members can come in, and by paying the amount of fees that is mentioned in the articles, can inspect the register of members. Obviously, he has to give a prior notice to the company. The minutes book, as I said, is divided between general meeting, the class meeting, the EGM or the AGM or the committee meeting. So you need to make sure that the minutes of meeting has been maintained as per the secretarial standards that have been issued, be it SS1 or SS2. You need to make sure that you actually comply with it. Okay, so apart from that, I think the other areas that we should discuss is the other registers. So one we can discuss at this particular stage is register of loans and investments. So if I quickly talk about those registers, I could just summarize it with you saying that the registers of so all of these things are something that you need to actually take care of, because whenever we talk about these, okay. Right. So just to give you a better understanding, I'll try to write it down for you. Okay. So if I talk about register of loans and investment, now you will appreciate the fact that if the company, has indulged in any kind of financial activities like loans and has made actually some kind of an investment, then they have to keep a record of it. The record will just not be for the benefit of the company, but for the benefit of the stakeholders as well. Plus, whenever an audit is being conducted, the auditor obviously can double verify or double check, because all the details of the loans and investment could also be taken from the balance sheet maybe, but whatever figures are there in balance sheet could quickly be or easily be reconciled with the register that has been maintained for that purpose. So you need to make sure that you have a separate register for that. There's a particular number that we say that has to be maintained in, so it is called as MBP2. Now with this MBP and the things of MBP2, we'll just quickly after this study 3, 4 and various others. So there's no form, you cannot download, these are not PDF forms that could be downloaded from the website, although there will be a specific format for that would be available in the terms of guidelines. So you need to make sure that you actually download that particular form, or maybe ask for for these kind of forms for to some of your colleagues maybe who will be able to help you in that. And these kinds of form would be just kind of a Word form which has been prepared by somebody manually, and you need to make sure that you actually amend it as per your requirements. So when I say amend, it means that you can probably add more points to it, but obviously you're not entitled to delete any of the mandatory fields. So you need to make sure that you maintain a register of loans and investments. Also, you need to make sure that whenever a company enters into contract, there's a particular registers that have been maintained. Any contract with the suppliers or maybe stakeholders have been maintained, and that particular thing will be maintained in a register called as MBP4. So MBP4 is a register for contracts. So these are the mandatory registers that have to be maintained. However, there are certain registers which are not required legally or on the statutory terms, but you make sure that if that's possible for you or for your organization to be a good corporate citizen, you actually maintain those registers as well. So a few of the registers includes a register of proxies. So proxy, as you may understand yourself, that proxies are those individuals who actually are attending the meeting on behalf of the members. So for example, there's a member called as Mr. A, and Mr. A obviously has invested certain amount of money in the company, but for some reason he is not able to attend the AGM of the company, the forthcoming AGM of the company. But Mr. A actually for some reason may not be able to attend, but Mr. A has nominated a person called as Mr. B. So Mr. B is obviously the proxy of Mr. A. So Mr. B would actually go to the meeting in which Mr. A has been called, and Mr. B would attend the meeting as if Mr. A has come to the meeting. However, needless to mention that there are certain restrictions that have been imposed as to what proxy can do or what the original member can do. So there are certain restrictions which only A can do, and B will not be entitled as a proxy to do that. So there are certain limitations, obviously, because in case a proxy is being given the same right as the member has, then obviously there would be no difference between the rights of these two individuals. So as a matter of fact, the rights of the proxies are less or have been reduced to a certain extent as compared to the right that you have for a general member who is attending the meeting on its own. Then there are certain registers that have to be obviously not mandatory, but in case you keep those registers, that should be good. Register of documents where common seal were affixed. So you have affixed a common seal maybe on the minutes of meeting, or maybe on some resolutions, or maybe some extracts, or maybe some kind of an agreement. So what agreements, what contracts, what documents are there? If you have maintained a register, you can actually note it down, the name of all those documents, maybe the date on which it was executed, and maybe those name who are actually parties to that particular contract or the agreement. So if in case you can just note it down, everything in that regard, obviously you'll be complying to most of the provision of the Act, and there's no reason as to why anybody could say that your company is a non-compliant company. Now let's move on to a thing called as annual return, which is obviously section 92 of the Companies Act 2013. Okay, so I think when we talk about annual return, as I said, it's under section 92 of the Companies Act. So I could just write it down for you. So the annual return has to be filed with the ROC within 60 days of holding the annual general meeting. So because whenever the AGM has been held, after that you need to file this annual return with the ROC at this particular point of time, and this has to be done within 60 days. You also need to make sure that the annual return has been filed in the form called as MGT7. Initially, there was a form called as 20B, that it's a E form 20B in terms of Companies Act 1956, but then obviously that is of no use for you at this stage. So under MGT7, you need to file the annual return. Obviously, the compliance for the listed and the unlisted company differs to some area, but I will come to that when we actually discuss that. There's also a thing called as Secretarial Audit. So the report of Secretarial Audit has to be filed in a form called as MR3. Now, we've already discussed various points on the Secretarial Audit side of things. So I would actually request you, if that's possible for you, and if you have actually gone through, you'll be able to appreciate the fact that the provision of secretarial audit has already been discussed in like the previous chapters and in the previous videos. But if not, then obviously you can go through it and obviously make yourself comfortable. So whenever a PCS actually submits a secretarial audit report, that has to actually be submitted in the form of MR3. Secretarial audit is being generally submitted in the form of report to the board of directors, and then the board of directors actually annex this report to the financial statement or maybe the notice of the meeting, which is actually sent to all the shareholders. Apart from that, whenever you actually allot any kind of shares, so which is called as the return of allotment. So whenever anything happens like this, then obviously if I talk about section, because sections are of great relevance, so if I just write it down the section for you, so it's section 39 of the Companies Act 2013. You have to submit a return of allotment in case you have done any kind of fresh allotment. Then you need to submit that particular return in a form called as PAS3, and that should be more than sufficient for you. Apart from that, there is a particular thing called as a return on buyback. So for example, I've already explained as to what is buyback. So you've tried to buy back the shares, some of your shares, some of the shares of your company. Now what was the result for that? You need to actually even starting buyback, you need to make sure that it has been authorized by the articles. Plus for buyback, obviously this is for sure that the company has to actually pay a certain amount of money to the stakeholders. So you need to make sure that you have those amount of money in your bank account. And as a result of this, it's mandatory for any company when they actually go for buyback that they actually file a declaration, of solvency, which will certify that they are solvent and will remain solvent even after the buyback is being sanctioned and has completed. So whenever the money has been given to the shareholders, the company would still remain solvent. So in that case, the company has to actually give this declaration in the form called as SH. So as I said, SH is generally for shares, and 9 is the declaration for solvency. Okay, now there's a complete list of things that you have to comply with. So there's just for simplicity, I'll discuss few of them just now, while the others will be discussed later on. So there are a few things that we need to make sure we are aware of that. So there's a particular thing called as special resolution, and the other thing is called as ordinary resolution. Now, what is special resolution? What is ordinary resolution? Primarily, this may not be of any relevance to you because you guys have already actually passed the executive stage. So, and even this is something that has been explained right back from the foundation stage. But just to give you a head up on that, because I don't want any topic to be left, don't want any topic to be leave behind, so that in case you have any questions or concern regarding the topic, and you may be thinking that I'll try and ask that. So beforehand, I'll try to resolve that particular thing, so that everything and anything which is just mentioned in the book, even in just one word, is something that you're aware of that. So any topic, even that has been discussed in the executive stage or probably in the foundation stage, you guys should be aware of that. The special resolution is like when, so first I will explain what is mentioned in the bookish language, 75% or more, while it says 50% or more. Now what does that mean? It means that, for example, there are 100 shareholders in the company, and you wanted to change the name of that particular company. So you need to make sure that 75% or more. So obviously when you say 100, you cannot divide an individual in two parts. So obviously it means that at least you need to have a consent of 76 people who are actually present in the meeting. So then only the special resolution will be passed. The ordinary resolution, as the word itself suggests, is like more than 50%. So in case the total number which are present in the meeting is 100, so if you want to pass an ordinary resolution, you have to be more than 50, and more than 50 obviously means 51. So you need to make sure that that particular thing has been passed. So obviously that has been complied with. So obviously special resolution, the word itself suggests, is only for those things which are special and which are of real prominence or real importance, while ordinary is just like a general fare, and that is the reason the percentage for passing the ordinary resolution is less as compared to the special resolution. In other words, the special resolution can also be called as 3/4, while it is just 1/2 or 1/2. There are few things under which a special resolution is mandatory required. In case you want to include the provision of entrenchment provision. Now, what is entrenchment provision? Can somebody tell me that? Entrenchment provision? Anybody? If you know the answer, obviously you'll try, and you should try and pause the video for a while and probably try and know the answer yourself. If you know the answer, try and probably memorize it in your mind. But if not, then obviously just go ahead and I'll probably let you know within just 2 minutes now. So, for example, rather than giving example, first of all, I'll explain what is the entrenchment provision actually means. So, for example, there's a particular thing called as maybe to change the name of the company require a special resolution. And for special resolution, I've already explained that you need to have the consent of 3/4 person who are present, which is obviously more than 3/4, which means more than 75%. So you require more than 75% consent, or more than 3/4 of so you require the consent of at least more than 3/4 of the people, or more than 75% of the people, to pass a special resolution. Now, this is something that has been mentioned in the Act. But in case you want to actually strong your hands on, probably you want to make this provision more strict. So what you can do is you can actually make a provision that no, although it's mentioned in the Act that 75% consent would be required, but as per our articles, you actually mentioned this in the article right away, that for changing the name of the company, instead of 75% or instead of 3/4, you'll require the consent of at least 80% individuals. So when you say 80%, you say that at least for changing the name of the company, you require the consent of more than 80% individuals or the shareholders. So when you say 80%, what you have done now, you have increased or probably make the provision of the law strong by their own means. So already the provision of law was saying that 75%, by your discretionary powers, what you have done is, instead of 75%, you have increased the proportion of the margin to 80%. So anybody now who wanted to change the name of the company has to make sure that they have 80% of the individuals on their side to change the name of the company. So rather than 75, you will now need the support of 80% people, and you have mentioned more than 80%, so you will require the consent of more than 80% individual. So entrenchment provision is basically, in simple words, like anything which is being done to probably make the provision of the law more strong. So I suppose you have already, I think, heard about a word called as ultra virus. Just hang on for a while. I think there have been some issues. Okay, so you've heard about a word called as ultra virus, and the other word is called as intra virus. Now, the reason I started with special and then ordinary and then entrenchment and now going to ultra virus, you'll appreciate the fact that without explaining special and ordinary resolution, I cannot go to the entrenchment provision. So whatsoever has been explained or will be explained in the near future or has been explained in the past has something or the other connection with the things that we're going to discuss. Maybe some point of time actually the student thinks, because I've also attended the online sessions and probably I've also taken the online classes, and a few of my friends also take the online classes due to the ease of time and the flexibility. But it may actually happen sometime that whatever questions we may have, the person on the other side, because we cannot actually interact with each other quite often. So what will happen is that the person on the other side may actually try and say whatever he or she feels like is important to us, but may not actually able to address the question that we have in our mind. So what actually happens is, while trying or while giving you the online classes, what I actually do is try and explain, as you also appreciate the fact by your own self, that I actually try and go into the details of anything and everything, but it may be just any word which you may already been aware of. Like, you cannot expect any student just in professional that any student is there who actually does not know the meaning of special resolution. But as you yourself see in your screen that I've tried, first of all, to explain the meaning of ordinary and special, and then actually related that particular thing to the entrenchment provision. Because as I just said, that entrenchment provision is something in which you make the provision of law more strict. You actually make the provision of law probably more compliant, and as a result of which you need to do everything to make sure that the provision of law are more strict and probably cannot be misutilized. So you enhance the range of those particular requirements. Like in the case of ordinary resolution, if I wanted to have the entrenchment provision, so I say like probably maybe to approve the annual accounts, I require the ordinary resolution. But no, I will not just be satisfied by the ordinary resolution, which is more than 50%. I'll try and go with 60%. So this is entrenchment. Entrenchment means adding something over and above the usual laws that are in place as per the requirement of Companies Act 2013. So you should make sure that you don't actually reduce their effect. And if you actually try and reduce their effect, obviously that cannot be done, and it would be termed as ultra virus. Ultra virus means null and void. So you cannot do that, but obviously you're more than welcome to enhance the requirement of the law to make them more and more compliant, or probably to make sure that they actually don't get misused in any of the area. The other thing that you actually should make sure is in regards to the way as to how the entrenchment provision can be done. Now, just to make sure that you are actually being aware that obviously there are two types of companies. I'll discuss that as well when I actually start the chapter in detail, because if I tell everything in each and everything in the brief section, then obviously it will be a problem for us, because you may actually realize that everything has been taught in brief in this chapter than what actually we're going to discuss in the detail section. And believe me that whatever we've been talking just now is just a brief, like I suppose it's already been more than or probably around 1.5 hours maybe, and prior to that there's also an introduction video which is almost somewhere ranging about 30 to 40 minutes. So altogether the introduction itself constituted about 2 hours. So you can yourself imagine when we actually go to the chapter how much detail orientation it would be. So obviously you shouldn't actually try and think that everything is being explained in brief in 2 hours. So there would be nothing or probably kind of a book reading in itself when we actually go to the detail, but that is not the fact. You'll realize that when we actually go on to the detail section. But because what I'm actually going to cover in those details section would be various things, obviously from the module itself. I think I've already retaliated the fact, but just now it has actually been probably brought in the form of words. So I'll try to probably mention that again, that in case you study subjects like due diligence of the Secretarial Audit, or Secretarial Audit and Compliance and Due Diligence, typically the name of the subject, from the study module itself, you can never be fail, or probably there is no chance as to why you should score less marks. Because throughout my life, I mean, I'm not sure I've already told this or not, but obviously we've been discussing these things, so I should actually bring this to your knowledge. That, I mean, obviously I can just write it down for you in case, obviously this is written everywhere, so I cannot hide it, but I'll try and probably even expose it to the more extent as possible. So this is my membership number. You can go to the website of ICSI, and in case you have sufficient time, there's an option available in the website in which you can check in how many attempts I've cleared. So you'll realize that I've just cleared in just first attempt. Every attempt, be it executive, obviously foundation, and the professionals as well. This is true that at my point of time, because the syllabus was old, so there were 8 subjects divided into 2 each, so 4 groups. So whatever may be the case, it depends upon the time. Obviously the course keeps on changing, so this is not something that I've done for myself, but obviously it's the ICSI. But I've just cleared it in first attempt. The reason is just the study module. In case you actually refer study module, then I suppose there's no way as to why you should get failed. So the more and more you actually focus on study module, obviously the more and more the chances are there for you to actually get easily through with this particular area. Okay, now so we actually come back to the special resolution things. So just for making it better understandable to you, I've cleared that particular thing. Okay, so whatever was written on the screen has been clear. Now please try and understand whatever I've been trying to explain to you through writing or through presentation. So if I actually talk about presentation is obviously a different thing, which I'll give it to you when we go into details of the chapter. But it was not possible to write everything on the presentation. That is the reason I've been trying to use, as you would see, white sheets to actually make you understand more practical approach. So a few of the things, one was entrenchment provision, and obviously I've told what it is, and so the thing that I'm actually trying to explain, and then we actually move to some different topic. This is sometimes that actually happens whenever you try and explain some of the practical things. You actually move towards that, and theoretical things actually get caught out. So obviously private companies and public companies, if you wanted to introduce the entrenchment provision in private companies, you can do that, but just by passing a special resolution. Just to make sure that I actually put this correctly. If you wanted to introduce entrenchment provision in private company, it has to be done unanimously. What does unanimously means? I'll explain this in a while. But for public company, it's like 75% or a special resolution. So if you actually get the consent of 75% or more individuals or the stakeholders, in case of public company, you can introduce the provision of entrenchment in the articles, but obviously for private company, it has to be unanimous. Now the reason as to why this is 75 and this is unanimous. So unanimous means 100%, like 10 on 10. So if there are 200 members maximum, and you already have issued the shares to that many, then you need to make sure that you also get the consent from all of these. So the reason I said it all 3 times, because that actually makes it difficult maybe, but that is the provision of law. But the reason why it is unanimous is like the limit, as I said, to the number of members is 200. Obviously, this is something that may be achievable, but for public companies, the members may be, right? I cannot actually get stopped even at that. So it can also increase to a further amount. So there's no limitation. What I mean to say is, so obviously you cannot make happy everybody and you cannot convince everybody. That is the reason it's not 100%, but majority, which is more than 75%. So by passing a special resolution in public company, you can introduce the provision of entrenchment in that regard. But for private company, you need to make sure that you have the consent of all individual, which is obviously 100%. So this is one of the area in which the provisions is required probably to actually introduce entrenchment provision. You need to pass special resolution. The other thing could be to change the register office of the company. So I'll just discuss few of them just now, but the other will be discussed in detail when we actually go to this chapter. The other is alteration of the AOA or the MOA. What is AOA and MOA? I think we'll actually deal with this. We've also discussed some of its parts, but we'll deal with this again in detail when we actually start this chapter. The provisions of variation of the rights of the shareholder. So variation means you're changing the rights of shareholder, maybe increasing or decreasing their rights. Most of the times maybe increasing their rights or decreasing their rights, because in case you're increasing the rights of shareholder, then obviously that would be good for him or her, but not for the company as a whole, because if you have 10 rupees and that is being divided between 10 individuals by 1 rupees each. Now if you are increasing the stake of some individuals, so this is divided between let's say A, B, C, D, E, F, G, H, I, J. So this is divided between 10 individuals, that's 1 rupees each. Now if you are increasing the stake of E to 1.5, then obviously it means either the share of D would get reduced, C would get reduced, or anybody's share would get reduced. So this is good for E, but not good for probably D. So you need to make sure that everybody actually has consent to that. You want to actually reduce the share capital, maybe related party transactions or loans and investments, liquidation of the company, and probably winding up or maybe sanctioning a scheme of amalgamation or a merger. For all of these, primarily you require the consent by way of passing special resolution. Now there are a few other things obviously which has been given to the board for their discretion. So you need to make sure that board is being given actually these powers to make the calls on shares, to buy back the shares, to invest the funds, maybe to borrow the funds. These are a few of the things that the board can do, because if you actually give every such powers to the shareholder, then you should appreciate the fact that shareholders may actually just meet once in a year, which is the form of AGM, or the other thing is EGM, which is extraordinary general meeting. So extraordinary general meeting cannot be held every day, and obviously because this brings a cost to the company. Plus, you require time, you require resources, you need to have arrange a place, you need to arrange for fooding, you need to arrange for transportation maybe. So that obviously is a thing that cannot happen. So whatever the things are there which are required for day-to-day operations of the company that have just been given to the directors, like the appointment of the Secretarial Auditor, and whatever things are there which are of prime or relevant important, that has been specifically dedicated to the shareholders, so that they are also aware of all those things and reason, and they can primarily decide as to what is right and what is wrong in that area. Okay, with this, I suppose we will be coming to the end of the chapter very soon, and then we'll start probably the detailed orientation for that area. So I suppose the other thing that we should discuss is in regards to the return for the appointment. So with return for the appointment of the managerial personnel, it means that whenever you actually, or the company is being appointing any CFO, maybe a whole-time director, manager, company secretary. So the company actually need to intimate this to the ROC by filing a particular form which is called as MR1. So that has to be filed with the ROC, and similar is the case whenever any particular director is being appointed or maybe getting resigned. The company has to actually file a form called as DIR12, and that has to be filed with the notice of the appointment. I mean the consent where the director has signed that he is willing to actually act as the director. So you need to select, I'll show you those forms as well. So you need to select the word appointment and then upload that particular attachment in case any director is getting appointed. While in the case of resignation, the director has to obviously submit a resignation to the company, and the company would file, within 30 days of that resignation, the company would file a form DIR12 and then attach the letter of resignation. Now what will happen in case the company hasn't filed those forms within the time period of 30 days? I suppose the only thing that is left is like the company needs to pay a fine or a penalty to the ROC. Now, how do we calculate fines and penalties? There's a particular calculator on the website of the Ministry of Corporate Affairs, so you can probably feel free for yourself to go to the calculator and probably then calculate the amount of late fees. It will also depend upon, so the late fees is not universal. It will depend upon the type of form that has to be filed and its basic fees, and then from there it will take how many days you are late, and then the fine will be calculated. Apart from that, there's one more thing, I suppose, or probably two more things. One is registration of the charges. I think we have already discussed that you need to actually maintain a register of charges in CHG 7. You need to actually file the charges in CHG 1. And probably there may be modification of charges that have to be filed along with that in the other forms. And then obviously once the whole of the amount has been paid, then you need to actually file a form which would be called as satisfaction of charges, and that has to be filed within 30 days of that whenever the satisfaction actually occurs. So it's all the responsibility of the company to make sure that these things happens, because in case the company didn't file a form with the creation of charge, then also please know that we have already discussed and you must have actually heard about it or maybe actually read about it in some of the textbooks of ICSI or maybe some other books, that in case you actually fail or the company actually fails to file the form for the registration of charges, maybe CHG 1 with ROC within 30 days and then probably not within even 30 days the company didn't file the form with the ROC. So please remember that by this the company would only be on the negative side, because this will not affect the right of the creditor. The creditor would still, in case of liquidation of the company or winding up, although that definitely would create a problem for the creditor as well. But it does not mean that the amount of money which the creditor has lent to the company would be zero. So it would still be the same amount which the creditor has lent. In case a company hasn't filed the form with the ROC, it is company fault. But the amount that the creditor has lent to the company would still be the liability of the company, and the company has to repay the amount with the terms and condition that are mentioned in the agreement. So, by non-filing of the chart does not mean that the company can go off with its liability and probably not pay the amount. This is something that will not be accepted. The other thing, I suppose, we'll just wrap this particular introduction section within the next 5 minutes, maybe. I think you must have actually heard about a particular thing called as FEMA, which is Foreign Exchange Management Act. Most of you actually maybe in love with FEMA and its provisions, while majority of you, because I know the intention of students sometimes, the majority of you may not like FEMA, or it may be the other case as well. But definitely the students actually, the students should actually be aware of the provision of FEMA, because in the today globalized world, maybe the company that you work for, or maybe the company that you actually do your internship with, or maybe the firm may have something to deal with foreign clients, and the foreign clients may actually purchase the shares in the company, or may they actually make any transaction in the company, or the company is planning maybe to issue the ADR, GDR, or probably ECBs, which is external commercial borrowings. So you need to make sure that you are well versed with the provision of FEMA. So when we talk about FEMA, obviously there are two routes by which you can make investment in India. If you remember, there's a word called as there's always this word has always been in the news for some of the other reasons, sometimes positive, sometimes negative. You'll appreciate that what's going on with Air India these days, and maybe Indian Railways, because these are the few sectors in which FDI, obviously in railways, obviously the FDI has now started. It was there even previously, but for Air India, I mean, in the aviation sector, the government is now actually checking the pros and cons, as with what is being told in the media report, that Air India would actually may sell some of its stake, probably a majority of its stake actually to get privatized, and it would be in the private hands. But they were showing on the television the other day that even that has happened in some of the countries of the world, that they have actually sold majority of the shares of their national carrier, or the government carrier, or the government aviation company to private sectors. But sometimes it actually has worked, while sometimes it doesn't. So let's see what happens. But FDI actually stands for foreign direct investment, because in this globalized world, the foreign investors obviously are the key players, because even if you are aware that in the stock market, especially in a country like India, the stock exchange or the stock market, you actually see that most of the money is being invested by the FDI, which is foreign direct investment, or maybe FII, foreign institutional investors. So obviously this has been the buzzword these days, maybe you can say that. But there are few areas in which FDI has been 100% allowed, but maybe some of the areas in which the FDI has just been restricted to 26%, or maybe 49%, or maybe specifically not allowed. So we have actually given the list of few of the activities in which I would say the FDI is prohibited. Like, you cannot actually probably take any amount from the foreign investors. So there are few things which is mentioned, saying that in gambling, because gambling is not allowed in India. Although I mean, to be on I would say on the practical side, I would say that although it is not allowed, and most of the things may not be allowed, but still those things happens. So it is up to the government to actually tackle all those things. But obviously in gambling, or in the activities like this, the FDI is not allowed. Similar is the case of lottery business and chit funds. I mean, we all must have heard about various frauds, be it Sahara or maybe any other NBFCs, which is a chit fund company. And chit fund company, the RBI is really strict on that area. I think day before yesterday, I was just reading on some of the Google News, maybe, that RBI will now try and probably reduce some of the complication that it have in NBFC, because at this particular point of time, setting up an NBFC is like a nightmare. You need to have this much amount of capital, you need to have this much amount of experience, because initially setting up of NBFCs was really simple. So NBFC, obviously you are aware, it stands for non-banking financial companies. It was really simple. But now with the advent of fraud that has been actually seen in the market, or the market has actually seen, RBI is actually very, very strict for the setup of the NBFCs, because with NBFCs there's a word associated called as, not sure if you heard about it, but called as para-banking. Now what is para-banking? It means like Obviously, SBI and the PNB and all these banks, all these PSU banks, obviously they don't have time to deal with the client, or maybe an individual who has come to the bank to deposit maybe 100 rupees in his bank account. They will actually not even, they don't even listen to those who actually come to have deposit 10,000. So you can yourself imagine what would be the position or reputation of that individual which has just come to deposit maybe 100 rupees or maybe even 50 rupees. They will not actually entertain that. Probably, I'm not saying that's wrong, but this is the kind of a mentality that they have, because they have been actually set up, or this is their mentality maybe, but not the government mentality, that they have been set up actually to cater the needs of those individuals who have huge amount of financial resources, and not for the poor or the needy. So that is the reason the government has issued various guidelines to various banks at various point of time, but nothing has happened. Obviously, all those paperwork is just a paperwork. So with the advent of time, it was felt that the poor section of the society maybe should also, or maybe the underprivileged, should not be left aside, and they should also be actually given the benefits of saving, because obviously, as you know, that saving is really important thing in our life. It could be used at any point of time, especially in emergency situation. So until unless you give the poor or the underprivileged the opportunity to save the amount, some amount of money, then you cannot actually actually blame them for any casualties that may happen from their families. So as a result of this, the concept of NBFC, then in that para-banking was introduced. Now, what is para-banking? Para-banking is the function of bank in which the individuals from NBFC usually come to your house, and probably they'll ask you whatever amount you can deposit. Maybe you said that every week I'll deposit 100 rupees, or every day I'll even deposit 10 rupees. So you can see that this is also the amount that they actually come to your home and then collect 10 rupees every day, or maybe 20 rupees. So obviously, I mean, this could be a joke of the year, that we say that we are going to the bank every week, every day to deposit just 10 rupees. You can yourself imagine what would be your reputation if you actually go to deposit 10 rupees, and how much time will you actually need to spend. So as a result of this, the RBI said, like, that we should actually set up something for the needs of the people who are poor and may not be able to deposit that much large amount of money with banks. So we should start and try with this, that the NBFC should be set up, which obviously would not be a bank or something like bank, but they will obviously function under the supervision or the guidance of RBI. And they are allowed to use the word financials or monetary, because they have been given special license by RBI. And what they will do is they'll go to the normal individuals, and probably whatever the amount of money that the individual want to invest, maybe 10 rupees, 100 rupees, 20 rupees, 50 rupees, whatever is the amount they'll take, and probably whenever the individual asks for the amount, they'll refund it. Now, till the time the amount was getting deposited, maybe 10 rupees, 20 rupees every day, the field executive were going and collecting that amount. But later on, as and when it actually being started far and wide and on a larger scale in India, the events of fraud started coming in, that the sales executive named as maybe Mr. A has come to my home and probably taken 10 rupees every day throughout the month. So obviously you can multiply this into this, which means 300 rupees a month. But and this has been, I've given this amount for about 10 years now. So if I actually say, or probably just a year maybe, just to make it simple. So 3600 is the amount, if I've calculated correctly, of the amount that I've given to that individual on the year basis. Now I want actually the amount to be sent back to me, because I have some personal necessities. Now when that individual actually goes to the branch of the NBFC to withdraw the money, he is being actually made aware that no, you have actually not deposited 3600, but we have just got 2000 rupees. Now that is the concern now. So where have these 1600 gone? So this is something that obviously a kind of a fraud that started, and probably this is just one example. This started with thousands and thousands of people, and then RBI actually got strict and probably introduced various guidelines in that regard. So this is the concept of NBFCs. So that is the reason the chip fund has been prohibited. Chit fund does not only include this, but various other activities which are unregulated sectors. Then the construction of farmhouses maybe, and then probably I would say Nidhi companies. So Nidhi companies are obviously to do with the investment side of the thing, so they are also prohibited. There are few checklists that have been actually mentioned when you actually bring FDI with the approval route and with the automatic route. So we'll discuss all of these and some of the prohibitions that have been actually made applicable to that. What is ECB? So ECB, as the word suggests, kind of an external borrowing. External means which has been done from outside India, and borrowing means you're borrowing a certain amount of rupees, or maybe a certain amount of money in form of dollars, maybe from the outside individuals or maybe outside companies. So there have been few guidelines that have been issued in that area, because whenever the ECB has been issued, or the ADR or the GDR has been issued, don't forget we also need to check the eligibility of the borrower, because it's always easy to borrow and then obviously really difficult to return. So you need to make sure that this has to be taken care of, and every individual has a responsibility to increase the reputation of his company or the country. So in case ECB are being actually taken or ECB have been issued to the foreign investor, and the company who's actually issuing that is not that much competent, so it would be the responsibility of the government that it shouldn't actually give the license or the approval to raise the ECBs. So we'll discuss everything in that regard once we come to that particular chapter as a whole. So this is pretty much everything about that, and as I said, we'll now probably start with the detailed orientation of this chapter. And obviously I've tried I think to explain everything in detail, although it was a brief session, but I've tried and explained everything that was possible that was not mentioned in the book, and some of the practical aspects as well. But now we'll just move ahead with the more practical side of things, and we'll try to figure out the chapter in detail. And as I mentioned previously, I think many times now, but I'll keep on mentioning so that you actually it's there in back of your head, that in case you have any questions or queries, please actually don't hesitate to contact me, or you're more than welcome to do so. I think if I could, even I'll have shown this at the starting of this presentation, or maybe as a short session, but I'll try and probably show you my details. So in case you have any questions or queries, you're more than welcome to actually contact me on my email address, and then probably I'll try and probably take your question forward and then respond to you directly. Meanwhile, I think I've also given some questions to SuperProf, and probably they'll be sharing it with you. So these are the questions that have been actually made on the basis of what I've taught. So in case you have any concern on those lines, then obviously you're more than welcome to discuss that with me as well. So I think that's all for the brief session, and I hope you really enjoyed the video. In case there's any problem with regard to the content, because as I said, I'm taking every content from the IC module plus over and above. I'm trying to add everything that's much possible for you. I think I've actually gone through the scanners as well, and I've actually explained some of the areas you may not realize, but I've actually covered some of the parts of the scanners. So in case you're using any publisher scanner, I mean, I'm not in a position to recommend you any specific scanner as such, but it would be my recommendation that yes, you use scanners for better marks and to save your time as well, and to actually study only those facts which are relevant to you. And I hope you enjoyed the video. So just let me know if you have any question. Now, just now we'll start within 2 minutes. I'll start a new presentation, and then probably I'll guide you the detailed orientation of this chapter. So we'll meet you then. Thank you so much. Thank you for your time.